Thank the senator. For what purpose the senator from Eastern Fairfax, Senator Servell, rise?
Speaking in favor of the floor substitute.
Senator has the floor.
Thank you, Mr. President. I just heard the word tort reform mentioned, and that got my attention. Because the interesting thing about this bill is it doesn't have anything to do with tort reform. Last time I checked, two businesses suing each other doesn't really have a whole lot to do with tort reform. And last time I checked, I go to the VTLA conference every year because I have since I started practicing law 22 years ago. I don't remember talking about business litigation there because it's not something they do. So I'm not really clear who's speaking for who in this so-called deal that got made. Nobody consulted me about it before it got made. Nobody came and said, hey, you know, what does the actual Senate think about this so-called deal? But last time I checked, we're the ones that approve deals, not other people. And the next thing I'll point out is, you know, I represent Gunston Hall in the 36th Senate District. Gunston Hall was the home of George Mason. In 1776, George Mason wrote our Virginia Declaration of Rights. And in what was then Section 11, today it's still in Article 1, Section 11 of our Constitution, it says that in controversies respecting property and in suits between man and man, we might want to tweak that a little bit, trial by jury is preferable to any other and ought to be held sacred. The word sacred appears once in our Constitution. Once. And it has to do with the right to trial by jury. And make no mistake, what this bill does is it takes away people's right to trial by jury without their consent. And that's a big deal. It's a fundamental alteration of the values of our state, going all the way back to its founding. The founding document that created this state in 1776, when we adopted this new system to free ourselves from the tyranny of England and unelected judges, people who weren't accountable to the people. That's why we said the right to trial by jury is sacred. And what this bill will do is it will allow a judge to take away a corporation's right to have their case heard by a jury, or a judge for that matter, basically without their consent. And that's a huge step. And I would ask you to consider that before you vote to allow somebody to do that without their consent, which is what the senator from Fairfax's, city of Fairfax's bill would do, was to say you can only do this with somebody's permission, with a litigant's permission, with their consent. Beyond that, this bill is not pro-business, it's pro-big business. That's all it is. That's pure and simple what it is. It is in favor of people who have a lot of money who can spend somebody under the table. That is all it is. One business can spend another business under the table. Or for that matter, you know, I represent a lot of folks who they're consultants. And to be safe, they incorporate as a single member LLC, but they're really just one person. Now, if that person gets in litigation with a big company, that person now waives their right to trial by jury, get hit by summary judgment pursuant to this bill because they chose to incorporate to protect themselves from liability. I think that's what the bill means. I have a whole other question about what this bill actually means. But simply because you choose to incorporate as a sole proprietor, you're now subject to getting thrown out of court without your consent on summary judgment, different than everybody else in the whole court system. That isn't pro-business. In terms of the cost, I don't like going to federal court. It's not a fun place, mainly because of this. And when you have to litigate a case in anticipation of a summary judgment motion, you have to litigate the case entirely differently because you have to be worried that somebody's going to take that deposition and use it in a summary judgment motion. You have to ask your questions different. You have to be more thorough. You have to go through everything. You have to depose more witnesses to defend yourself against the summary judgment. You have to do a whole lot more work whether or not they file it or not. The main people that are going to benefit from this, aside from big business, are lawyers. Because those of us who do commercial litigation are going to have a real chance to run our bill up, which is going to get passed on to these businesses, it's going to get passed on to consumers because this bill passes. It's a bad idea. We'll talk about my amendments if this floor amendment doesn't pass. But we need to pass this floor substitute because this should not happen without the consent of everybody involved in the situation. It's a fundamental change in the Virginia justice system.
Thank the senator. Okay. All right. Senator from Fairfax City, Senator Peterson.
Thank you, Mr. President. If no one desires to speak, I'd like to speak twice, and I'll keep it. Ladies and gentlemen, I'm going to keep this super brief, and if I go over 60 seconds, raise your hand and I'll shut up. I'm in the courthouse. That's not 60 seconds, gentlemen. I'm in the courthouse every Friday.
At least 8 hands.
I'm in the courthouse every Friday. And I look up on that docket board, and so I know who's in the courthouse defending their interests. You know what names I see? Kim, Nguyen, Mohammed, Abdul Hamid. Those are the types of names that people I'm representing, we're representing. Those are the businesses and the business owners, okay? I didn't see any of those folks in front of the Courts of Justice Committee. So when you hear a quote, the business community, are they the business owners in your neck of the woods? Are they the business owners in your neck of the woods? They're not the business owners in my neck of the woods. It's the biggest businesses. They're already taken care of, and if they want to litigate by summary judgment, by God, they can make an agreement to do so under my amendment. But as to the little guy, I'm going to go down fighting for him. So please support my amendment. Thank you.
Thank you, Senator. The question is, shall the floor substitute be adopted? All in favor of the motion will say aye. Aye. Those opposed, no. No. Chair is uncertain. We'll have a recorded vote. All in favor of adopting the floor substitute will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote? Clerk, close the roll.
Ayes 16, noes 21.
Ayes 16, noes 21. Floor substitute is not agreed to.
Mr. President,
Senior Senator from Chesapeake, Senator Cosgrove.
does that mean we have to hear from Senator Serville?
I think it does.
Oh, man.
Senator from Eastern Fairfax, Senator Serville.
Thank you, Mr. President. I'd waive reading of floor amendment number 1.
Thank you, Senator. The question is, shall the reading of floor amendment number 1 be waived? All in favor of the motion will say aye.
Aye.
Opposed, no. The ayes have it. The reading of floor amendment number 1 is waived. Senator from Eastern Fairfax, Senator Serville.
Thank you, Mr. President. Ladies and gentlemen, I move the floor amendment pass and speak to that motion.
Senator has the floor.
Thank you. Ladies and gentlemen, well, now that we're going to go down this road where we're going to take away people's right to a trial by papering them to death, what this bill basically does, what this amendment does, is it says that if any judge grants a motion for summary judgment, that person has a right of appeal to the Supreme Court of Virginia to have it reviewed. Right now, the Supreme Court of Virginia only hears your case if they give you permission. That's very unusual. I think Virginia might be, if it's not the only state, it is one of the only states in the country where you do not have a right of appeal, not have a right to have your case reviewed before on appeal. And I think if we're going to do something as significant as take away somebody's right to a trial, that we need to make sure people have the right for an appellate court to actually look at it, to make sure the right decision was made before that decision becomes final. And I would ask you to adopt the floor amendment.
Thank you, Senator. For what purpose is Senator from Rockingham, Senator Obenshain, rise?
Mr. President, I rise to speak in opposition to the floor amendment.
Senator has the floor.
We heard about George Mason, Gunston Hall, the Bill of Rights, this fundamentally changing Western civilization as we know it. And I want you to know that this bill, unamended, does not do that. It does not deprive anybody of their right to jury trial. It does not deprive anybody of their right to appellate review. What this does is it says if a reasonable jury could not find in favor of one side, then summary judgment should be granted. And that is the same standard by which any appellate court reviews a case. Now, it is important to point out that this is not some notion, the status quo ante, that is being modified by this bill is not something that emanates from our founding fathers. It was not embedded in the Bill of Rights or Virginia's Statute of Religious Freedom or any of the other foundational documents of this nation. It was adopted in the 1960s as a consequence of a member down the hall named George E. Allen, Jr., who decided that we needed to do away with summary judgment in civil justice in the Commonwealth of Virginia. We had it. We had it. And what this does is it simply says that in this limited class of cases, summary judgment can be obtained using a deposition. Now, let's look at the right of appeal. We've got an appellate review process. Every single case that is tried in the Commonwealth of Virginia in the circuit courts is reviewed or can be reviewed if the parties, if the loser petitions for an appeal in the Supreme Court. Every single one of those petitions for appeal is reviewed by the court, and you get a hearing before a panel of the Supreme Court that considers the appeal, a 3-member panel, and they consider your appeal. If it's meritorious, you're heard by the whole court. But every single litigant has a right to appellate review. This does not change that. And what this will do is it will make it virtually impossible for the Supreme Court to manage the caseload that will be created as a result of this, because it will eliminate that 3-member review and will require the entire court to evaluate and to hear argument and to require briefs in every single one of these cases. And if you think that the bill unamended is going to create a burden for small businesses, just wait until this happens. Because that small business that wins the case isn't going to be able to simply win the case and be done with it with the knowledge that if it's a good, solid verdict decided or judgment by the court decided consistent with the law, that the case will be over upon review by that 3-member panel. What this will do is say that that small business has to go through a full-blown appeal before the Supreme Court with the submission of those thousands of pages of appendix, with the submission of briefs and replies, and both sides going for oral argument. This is going to impose a burden on those small businesses like nothing else.
Thank the senator. For what purpose is the senator from Eastern Fairfax? Senator Servell, rise.
Nobody else desires to speak. Speaking very briefly.
Senator has the floor.
Thank you, Mr. President. I heard the gentleman talk about how you have a right of appeal to the Supreme Court. You don't. You have a right to 3 judges to look at it and try and decide whether they want to give you an appeal. And I would note that last year, according to one of my favorite blogs, the Supreme Court received 3,000 requests for appeal last year. And I think out of those 3,000, they let 115 in the door on the civil side and 38 in the door on the criminal side. The Supreme Court doesn't hear many appeals. That's historically one of the lowest numbers they've ever heard, both numerically and as a percentage. They're hardly taking any cases. And that's why you need a right of appeal, because you don't get an appeal in Virginia. We're, like I said, one of the only states in the country where you don't have a right of appeal and don't have a right to an appellate court to look at what one of these circuit court judges did. You only have a right of appeal in divorces, workers' comp, and workers' comp. And from what the old-timers tell me, divorce trials got a whole lot better after judges knew you had the right to get your case heard. There needs to be accountability. And on this summary judgment stuff, if we're going to be enacting this big remedy, these people need to have the right to appeal. I'd hope we adopt the amendment.
Mr. President, I'd ask if the gentleman from Southern Fairfax would yield for a question.
From Eastern Fairfax, Senator yield?
Yes, happy to.
Senator yields. You have the floor.
Mr. President, what I would ask the gentleman is, of those 3,000 cases that he cited in which there were petitions for appeal that were filed, is it not true that there is a panel hearing in every single one of those 3,000 cases before an appellate panel of the Supreme Court of Virginia?
Senator has the floor.
Mr. President, I would say the gentleman's a panel hearing if you don't file a response to the appellee's written brief.
Mr. President, I'd ask a follow-up question. Does the gentleman agree that there is an opportunity to be heard by a panel of the Supreme Court of Virginia in every one of those 3,000 cases?
Senator has the floor.
Mr. President, I would say to the gentleman that every person who appeals has the opportunity to speak for about 10 minutes to 3 randomly selected judges of the Supreme Court to see if you can get them to accept the case.
I thank the gentleman.
Thank you, Senator. Question is, shall the floor amendment be adopted? All in favor of the motion will say aye.
Aye.
Those opposed, no. No. Chair is uncertain. We'll have a recorded vote. All in favor of adopting the floor amendment will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote? Clerk, close the roll.
Ayes 12, noes 26.
Ayes 12, noes 26. Floor amendment number 1 fails. Senator from Eastern Fairfax, Senator Servell.
I move to waive reading of the floor amendment.
Question is, shall the reading of the floor amendment be waived? All in favor of the motion will say aye. Those opposed, no.
I move passage of the floor amendment unless people really want it to be read. Speaking of the motion.
We still have to do. This is going to be fun. The waiving of the reading. Let's retake that vote. Question is, shall the reading of the floor amendment be waived? All in favor of the motion will say aye.
Aye.
Those opposed, no. The ayes have it. The reading of the floor amendment is waived. Senator from Eastern Fairfax, Senator Servell.
Move adoption of the floor amendment. Speaking of the motion.
Senator has the floor.
Ladies and gentlemen, all this one says is that this bill doesn't become effective unless we give every circuit court judge in the state a law clerk. Just so you all know, the state actually doesn't provide law clerks to any circuit court judges. The localities do. But there are about 30% of the circuit courts in the state, these judges do not have law clerks. And I can tell you that when we start dumping 5 pounds of paper on these judges for a Friday afternoon that they got to process, they can't do it without a law clerk. Most federal judges have 2 or 3 law clerks plus interns, and now we're asking our circuit court judges to do it in many parts of the state without a law clerk. We need to give law clerks, if we're going to give them this responsibility, we're going to jam up our courts. They're not going to be able to move cases if we don't give them more resources, given what you all just voted to do.
Thank the Senator. For what purpose is Senator from Rockingham, Senator Obenshain, rise?
Mr. President, I rise to speak in opposition to this floor amendment.
Senator has the floor.
Mr. President, I certainly believe that we need to make sure that our judges have the resources to handle the cases. As a matter of fact, we last year created a significant number of new judgeships in the Commonwealth of Virginia that will enable the court system to address any increased demand caused by this. I would also point out to the gentleman that the rules impose a page limit upon the filing of memoranda in support of motions. And absent consent of the court, those limits exist and remain in effect. So I would respectfully submit that while I appreciate and understand the concerns that have been articulated, I would submit that this is a thinly veiled but still transparent effort to prevent this bill from securing passage. So I would respectfully submit that this is perhaps a inadvisable amendment at this point. Thank you.
Thank you, Senator. For what purpose is Senator from James City County, Senator Norment, rise?
Thank you, Mr. President. I am inquiring whether the patron of this floor amendment would yield for a question.
Will the Senator yield?
I'll yield.
Senator yields. You have the floor.
Mr. President, as I look forward to next week when we perhaps will somehow get into some meaningful discussions about the budget, I ask this question not with my attorney hat on, but from the Senate finance perspective. I would ask the Senator how much was the budget amendment that you submitted to cover these clerks for the 30 judges?
Senator has the floor.
Mr. President, I would say to the gentleman I did not submit a budget amendment because I didn't have a bill about this, although I have in the past. But I would note that when the Supreme Court issued a report to me at our request last year, the Chief Justice advised me that if the Commonwealth would undertake to fund law clerks for judicial circuits currently without clerks, the cost would be 76 clerkships, or $5.6 million annually, or I think he says 5.6 annually or 7.3 million statewide, which I'm happy to give you this report if you'd like to see it, but I did not put in the budget amendment because it wasn't my bill.
My last question, Mr. President, is the gentleman aware that the deadline for filing budget amendments has expired?
Senator has the floor.
I would say to the gentleman that I am aware of that, and not having the privilege of being on the Finance Committee or a budget conferee and all the magic things that happen in those meetings, I was hopeful that persons with more power than me might be able to come up with the money if they felt this was an important policy priority for the Commonwealth.
Thanks, Senator. Question is, shall the floor amendment number 2 be adopted? All in favor of the motion will say aye. Aye. Those opposed, no. No. The noes have it. The floor amendment fails. Senator from Rockingham, Senator Obenshain.
Mr. President, I move the bill be engrossed in advance to its third constitutional reading.
Thank the Senator. The question is, shall the bill be engrossed in advance to its third reading? All in favor of the motion will say aye. Aye. Those opposed, no. The ayes have it. The bill is engrossed in advance to its third reading.
Senate Bill